Please get ready for dictation of transcription number 312 from Sir Kailash Chandra magazine. It is an extract from the statement made by the Rehabilitation Minister. 5 seconds to go. Start. In the extraordinary situation created in the wake of the partition, it became necessary to enact a law to deal with the properties left by the evacuees. In the first instance, various state governments enacted their own laws. The central law on evacuee property was enacted in 1950. With a gradual return of the conditions to normalcy, it became possible to relax the provisions of this law. In 1950, the provisions relating to intending evacuees were done away with, and the procedure for confirmation of sales under Section 40 simplified. A year later, in May 1954, the next step towards further relaxation was taken, and the necessary amending legislation passed in October 1954. The amending law provided that no person could be declared as evacuee for any action of his after the abrogation of the law. It also provided that no notices could be issued after the expiry of 6 months from the date of its enactment, that is, after the 7th April 1955. In May 1955, we found that nearly 2 lakh cases were pending under the Evacuees Property Act and the Allied Act relating to the separation of evacuee and non-evacuee interests in composite parties. The size of the problem was thus fairly large. So long as large numbers of cases remained pending, thousands of persons who were involved as parties in these cases would remain in a state of uncertainty. We thought that it was our foremost duty to ensure the expeditious disposal of these cases. We therefore studied the working of the Act to look for any relief which could be afforded to the members of the minority community within the 4 corners of the Act. We found that about 9,000 Muslims had applied for the restoration of their properties under Section 16. It was urged that the officers of the Custodians Department tended to insist on very rigid proof of continuous stay in India in the form of ration cards. Instructions were therefore given not to insist on ration cards and to accept other collateral evidence as proof of residence in India. Even oral testimony of respectable witnesses living in the neighborhood could be accepted. For the disposal of the pending applications, 3 special officers have been appointed in the ministry. Another matter which came to our notice related to persons who had occupied vacant evacuee properties without permission, taking advantage of the abnormal circumstances prevailing after the partition. It seemed unfair to us that after all these years, large-scale dislocation of these persons, many of whom were Muslims, should be caused by asking them to leave the houses. We therefore decided that occupation by those persons who had occupied the premises on or before the 31st December 1950 may be regularized, provided that the arrears of rent were paid. To help those who were unable to pay the arrears of rent, the facility of payment in 12 installments was given. In regard to the large number of judicial proceedings pending in the custodian's department, I wrote personally to every custodian expressing my deep anxiety in the matter and the need for speedy disposal. I also pointed out to them the desirability of taking a broad view of evacuee property cases and not to be guided by narrow or legalistic considerations. As a result of the persistent efforts in this direction, the number of cases has been brought down to less than half. Not content with the above measures, a thorough review of the provisions of the evacuee property law was carried out with a view to finding out whether any of the provisions could be amended with a view to simplifying the procedure. The present bill, which has been passed by the Lok Sabha, is the outcome of this examination. I would like to mention some of its important features. Another matter which came to our notice was that the custodians were sometimes using the provisions of Section 6, which empowers them to exercise superintendence and control over the subordinate officers, to reopen cases already decided under the provisions of the Act. In order to obviate improper use of this section, it is being made clear through Clause 2 of the bill that the custodian will not question judicial orders passed by the subordinate officers under the general powers of superintendence and control. The power of superintendence and control of the custodian general is, however, being retained. In cases of glaring injustice, the custodian general would be able to rectify matters by passing orders under the provisions of Section 27, which give him the power to call for the record of any proceedings for the purpose of satisfying himself as to the legality or propriety of any order and to pass a suitable order on it. It has been provided that the custodian general should be able to condone delays under the Indian Limitation Act. Stop.